The goal of the balance bench is to explore how the world's two predominant legal systems, the adversarial and the inquisitorial, can be bridged to create a more equitable, transparent, and effective system of justice. In many countries, including those following the English common law tradition, justice is administered primarily through an adversarial system. In others, particularly those influenced by continental European traditions, inquisitorial models hold sway. Both systems seek to deliver justice, and both have evolved to reflect the values and historical contexts of their societies. Yet, neither system is without its critiques and limitations. In this opening chapter, we will lay the groundwork by examining the basic tenets and historical origins of adversarial and inquisitorial processes, detailing the strengths and drawbacks that each system presents. We will then consider how legal reforms and changing socio-political landscapes have shaped these models and made a balanced bench approach an attractive proposition. In setting out these foundational points, we aim to illustrate the need for a third path that meaningfully integrates the virtues of both systems, while mitigating their individual shortcomings. Historical context of legal systems. Although humanity's desire to resolve disputes fairly can be traced back thousands of years, the formal structures of the modern adversarial and inquisitorial systems primarily emerged in the Middle Ages. In the English tradition, the adversarial system grew out of customary practices of dispute resolution that involved trial by ordeal, trial by combat, and, eventually, the jury system. Over time, these practices shaped the prevailing belief that the best way to arrive at truth is for two opposing sides to present their arguments to a neutral arbiter, originally a judge, later supported by a jury, who would weigh the evidence to reach a conclusion. Meanwhile, on the European continent, the inquisitorial model was heavily influenced by Roman law and the canon law of the Catholic Church. The Church's procedures emphasized the active role of the judge or inquisitor in gathering and evaluating evidence, a practice believed to ensure that the truth is uncovered through a more thorough and impartial investigation. In certain parts of Europe, such as France and Germany, this inquisitorial tradition evolved into a state-centered process. The judge was viewed less as an umpire between two parties and more as a proactive facilitator of justice, vested with the authority to direct inquiries, call witnesses, and supervise investigations. Over centuries, these foundational models influenced various legal traditions around the globe. Former colonies of Britain adopted the adversarial system, embedding it into their courts and legal procedures. French or Spanish colonial influence spread variations of inquisitorial practices across parts of Africa, Latin America, and Asia. As a result, the modern legal landscape is a tapestry of these two broad approaches, often with unique national adaptations. Understanding this context is crucial to appreciating why blending adversarial and inquisitorial elements may offer a more nuanced and effective path toward justice. Philosophical underpinnings. To fully understand the adversarial and inquisitorial traditions, one must also examine the underlying philosophies guiding each system. In essence, the adversarial model arises from the liberal democratic tradition that places a high value on individual rights and freedoms. It positions the parties themselves, often through their attorneys, in charge of presenting evidence and arguments, fostering a system that seeks to protect individual liberty against an overreaching state. Through robust cross-examination and strategic advocacy, the truth is assumed to emerge when each side is allowed to challenge the other vigorously. By contrast, the inquisitorial model places a premium on communal values and the responsibility of the state to actively pursue justice. Instead of leaving the evidence-gathering process to the opposing parties, the court takes the lead in discovering facts. This philosophy underscores a societal view that truth is best found through a comprehensive, impartial inquiry, rather than a contest. The judge functions like an investigator, collating information to ensure that justice is administered with minimal influence from private biases. Neither philosophy is inherently superior. Each stems from different conceptions of human nature, individual rights, and the role of the state. The adversarial tradition aligns with the notion of protecting individual liberties by ensuring that the government bears the burden of proving its case. The inquisitorial tradition aligns with the idea that society, through the instrument of a neutral judiciary, should actively pursue a factual inquiry into wrongdoing, rather than rely on a battle of lawyers. Recognizing these philosophical roots will assist us in formulating a balanced model that respects both individual autonomy and communal responsibility. Key characteristics and strengths. Adversarial advantages. Advocates of the adversarial system point to its protective structure, especially as it pertains to the rights of the accused. This system makes it abundantly clear that it is the prosecution's burden to prove guilt beyond a reasonable doubt. Defense counsel, in turn, is free to explore any deficiencies in the prosecution's evidence. Such robust advocacy can be potent in preventing wrongful convictions. Additionally, the adversarial model emphasizes the fairness of procedure, ensuring that each party has its day in court and a fair opportunity to present and test evidence. This fosters a sense of due process that resonates strongly with societies that prioritize individual rights. Another strength lies in the adversarial system's reliance on cross-examination. The theory is that truthful testimony will stand up well under rigorous scrutiny, while false or misleading accounts will unravel. The process encourages thorough questioning of all parties and witnesses, aiming to expose inconsistencies or fabrications. Over time, this method has proven itself reasonably effective in uncovering the reliability of evidence, although it can be influenced by disparities in legal resources between the parties. Nevertheless, advocates of the adversarial approach argue that such an open contest promotes transparency and a sense of procedural justice. Inquisitorial advantages. On the other hand, the inquisitorial system boasts a thorough, judge-led investigation designed to minimize the risks associated with purely adversarial contest. Here, judges generally have more autonomy to question witnesses, direct the course of investigations, and ensure the comprehensive examination of facts. Rather than expecting that two opposing sides will produce all the relevant evidence, inquisitorial systems entrust this responsibility to a judicial or investigative authority. In theory, this removes the incentives for either party to hide or downplay evidence that could benefit the opposing side. Many proponents of the inquisitorial approach contend that it can be more efficient in certain types of cases, because the court guides the gathering of evidence rather than waiting for parties to produce it. The process can, in some instances, proceed with fewer procedural battles over disclosure, discovery, or evidentiary issues. The inquisitorial system's commitment to the truth-finding function resonates with those who believe that justice is best served when a judge or panel of judges is empowered to act as an active seeker of the truth, rather than a passive referee confined to ruling on objections. Criticisms and limitations. Adversarial critique. While the adversarial approach can protect individual freedoms, critics argue it may inadvertently privilege those with superior resources or more skilled representation. When trials turn into battles of lawyers, the financially disadvantaged party may be at a marked disadvantage, even if they have a legitimate case. Moreover, the adversarial emphasis on strategic advantage can, in some instances, distort the pursuit of truth. Lawyers might withhold certain lines of questioning or emphasize technicalities at the expense of clarity, leaving judges or juries burdened with parsing out the facts amid layers of legal maneuvering. Additionally, the adversarial model has been criticized for potentially traumatizing victims or witnesses, who must endure intense cross-examination. The aim from a defense perspective may be to weaken witness credibility, but the effect can be re-traumatizing or intimidating for those testifying. Consequently, some argue that this hyper-competitive environment may compromise the overriding goal of justice by placing undue stress on the victims of crime and discouraging some witnesses from coming forward. Inquisitorial critique. As for the inquisitorial system, skeptics warn that granting judges or investigating magistrates such a central role in evidence gathering can yield an excessive concentration of power. If a judge or investigating authority is biased or makes an incorrect initial assessment of a case, the entire direction of the investigation, and therefore the trial, might be skewed. The formal guarantee of judicial neutrality is meant to mitigate this risk, but critics argue that human limitations, systemic pressures, or lack of resources can all lead to flawed outcomes. Furthermore, inquisitorial procedures can sometimes be perceived as less transparent. Because judges or officials control the discovery of evidence, defendants and their counsel might feel shut out of the investigative loop. While reforms in many inquisitorial countries now ensure defendants have substantial rights to challenge evidence, some critics maintain that these safeguards fall short of the robust, party-driven framework afforded by the adversarial system. As a result, the question arises whether an active, state-led approach can fully protect an individual's right to a fair defense. The changing landscape of justice. The modern world presents a complex array of legal challenges, ranging from global financial crimes and cyber offenses to international terrorism and transnational organized crime. As legal systems confront increasingly sophisticated types of wrongdoing, both adversarial and inquisitorial approaches have had to adapt. Indeed, many countries are already experimenting with hybrid forms: inquisitorial-style investigations in preliminary stages, followed by adversarial-style trials, or specialized judicial roles that merge investigative and adjudicative functions. At the same time, public expectations for greater transparency and fairness have never been higher. Media coverage of high-profile trials and instant social media commentary have placed courts under intense scrutiny. Cases involving issues of social justice, such as race, gender, and class, further highlight the inequities that can result from relying solely on one model of dispute resolution. Likewise, scientific and technological advancements have complicated the fact-finding process, requiring legal professionals to understand complex forensic evidence and digital traces. In this environment, clinging steadfastly to only one traditional model of justice, adversarial or inquisitorial, can seem ill-suited to the demands of the 21st century. Toward a balanced bench. It is against this backdrop that we introduce the concept of a balanced bench. The idea is simple yet profound: to create a framework that integrates the best of both adversarial and inquisitorial systems, while minimizing their inherent weaknesses. Such a framework recognizes that robust cross-examination and party-driven presentation of evidence can protect individual rights and uncover inconsistencies. But it also acknowledges that a proactive inquisitorial-style inquiry, where judges take on investigative roles, can be invaluable in ensuring no relevant piece of evidence is overlooked. A balanced bench would, in essence, empower judges to ask questions, introduce issues that neither party has raised, and ensure an exhaustive search for the truth, while still allowing each side the opportunity to test and challenge the evidence thoroughly. The key is to carefully delineate procedural rules to prevent judicial overreach, while safeguarding the defendant's right to a fair trial and the public's right to justice. In practice, this means introducing measures to detect and correct potential judicial bias, ensuring transparency in the evidence-gathering process, and providing equitable resources so that one party is not overwhelmed by the other's greater financial or institutional power. Summary and roadmap. In this first chapter, we have laid out the fundamental context for why a balanced bench is necessary. We explored the historical evolution of the adversarial and inquisitorial systems, noting their philosophical underpinnings and contrasting strengths. We also examined the most pressing critiques of each model, particularly regarding resource imbalances, judicial neutrality, and procedural fairness. Modern legal systems, faced with evolving types of crime, heightened social awareness, and technological complexity, are often straining under the weight of these challenges. In the following chapters, we will delve deeper into the specific mechanisms by which a balanced bench can be realized. We will discuss how judges might balance an active investigatory role with an unbiased stance, how cross-examination might coexist with judicially directed inquiries, and how procedural safeguards might be instituted to protect individuals' rights while ensuring that justice is not merely a product of superior lawyering. We will also look at comparative case studies from jurisdictions already experimenting with hybrid models, assessing what lessons can be learned and how they might be applied more broadly. Ultimately, the balanced bench proposes a judicial architecture that breaks free from the rigid either-or choice of adversarial versus inquisitorial. Instead, it envisions a flexible and holistic model that adapts to the complexities of modern justice. We invite you to join us in this exploration of how legal systems can evolve to safeguard individual liberties, uphold rigorous standards of proof, and facilitate genuine truth-seeking. These objectives are not mutually exclusive. Rather, they are complementary aims that, once integrated, can position our courts to better serve the ideals of justice for generations to come.